The Premack Virtual Online Law Office presents attorney Paul Premack with this week's legal column, published in the San Antonio Express News on mysa.com and on our website at www.premack.com. This week's topic:
Dear Mr. Premack, my father left me land and a house in a life estate. He kept the right to live there till his death, and any proceeds the land may incur, such as lease money. He is not living on the property, and I want to clear shrubs and trees from the land and use it for cattle. Can he stop me from using the land? Signed, B.M. From your description, it sounds like your father used a traditional life estate arrangement. Under it, Texas law says that he retains all control, use, and enjoyment of the property so long as he is alive. Texas law further states that at the moment of his death, all those rights are transferred to you instantly. But so long as he's alive, Texas law states your rights are extremely limited. You can veto the sale of the property, and you're entitled to ownership upon his death. You have no right to enter the property without his consent. You have no right to clear shrubs and trees without his consent. You have no right to run cattle on the land without his consent. Thus, your best plan may be to seek his consent, and perhaps lease the land from him under an agreement that terminates at the moment of his passing. Dear Mr. Premack, my parents left me their property via a ladybird deed, but my sister lives in the house and has for over a year, and she's not worked in years nor cared for my parents. I'm the only one on the ladybird deed, but I understand if my mom was receiving Medicaid, the state of Texas will go after the property. The elder law attorney we saw in 2008 told us this would protect the property from estate recovery. Now I read online that the state of Texas will come after the property to recover Medicaid funds spent on my mom anyway, and the ladybird deed does not protect the property from having to be sold with the money being returned to the state, unless a son or a daughter has been living in the home for over a year with no income. Is this true? Signed, ADC. A ladybird deed is an expanded form of life estate. Your mother has all the rights that exist under a traditional life estate arrangement, as well as the right to sell the property and to cancel your right to inherit during her lifetime. This arrangement is used under the Medicaid system to avoid MERP, the Medicaid Estate Recovery Program, because the arrangement avoids transfer penalties under the Medicaid rules. MERP itself has limited legal rights under Texas law. They may bring a claim to recover money spent by the state on a Medicaid patient like your mother, but that claim may only be brought in probate court after the patient dies, when his or her will is admitted to probate. The claim is paid from the deceased patient's remaining assets, which may require that the house be sold so the claim can be satisfied. A ladybird deed transfers title to the house without reference to a will and without probate. Thus, the state has no forum in which to bring a claim, and the deceased patient legally does not own the house after the moment of death. Whenever you read online, whatever you read online was incorrect. The state of Texas still reluctantly honors ladybird deeds as a MERP avoidance technique because the law limits the state's options. Your reference to a son or daughter living in the house for over a year with no income is an inaccurate mashup of other legal ways to avoid MERP. Check Chapter 3 of my book, The Senior Texan Legal Guide, now in edition 6.0, at Amazon.com or Barnes & Noble for those exceptions. Dear Mr. Premack, after nearly 40 years, I'm recently divorced. Part of the divorce agreement was that my now ex-husband has to pay support to me. Does that support have to be included in my income? Signed, VF. I would suggest you ask your accountant, but federal law states that routine support payments received pursuant to a divorce decree are taxable to the recipient and deductible by the payor. Further, there are federal tax rules that require the payment to be in cash or its equivalent, that you and your ex cannot reside in the same household, and that you cannot file joint returns. On the other hand, assets transferred pursuant to the divorce, like bank account balances or real estate title, are not included in your taxable income.